Hey guys, welcome to my legal classes. This is Ganesh Pujari and I have come up with a reading session where I am going to read out all the 10 chapters, that is the original 7 chapters of Industrial Dispute Act along with 40 sections, and then the amendment chapters that are being added. There are 3 amendment chapters along with 39 sections which are being added. Now there are total of a kind of 10 chapters along with 79 sections. I am just going to read out the list of all those 10 chapters along with the 79 sections. Now, why is this necessary? When you are answering in your exam on any question related to Industrial Dispute Act, the first and foremost thing that you need to have in your brain is the structure of this particular act. You need to know how exactly are the chapters framed and then how exactly it is moving along with the sections. If you know that, then your answer will become very easy. That way, I recommend you to watch this video at least 2 or 3 times and try by heart the sequence so that you can structurally answer any kind of question related to Industrial Dispute Act. Remember, for most of the courses which are on labor laws, the Industrial Dispute Act takes lot of portion from it because that important is this act when it comes to labor laws. With that, I am taking you to the structure. Chapter 1 is preliminary chapter which discusses about short title, extent and commencement. Remember, this act is applicable in Jammu Kashmir also, and this act came with effect from 1st April 1947. And section 2 discusses about definitions, and then comes the very important amendment section, that is section 2A, which discusses about dismissal etc. of an individual workman to be deemed to be an industrial dispute. There we are going to discuss a lot of case laws. And then comes chapter 2, which is about authorities under this act. Here we see works committee, conciliation officers, boards of conciliation, courts of enquiry, and then labor courts. After that, we got 3 amendment sections in the form of 7A, that is tribunals, 7B or national tribunals, and 7C disqualifications for the presiding officers of labor courts, tribunals and national tribunals. Then section 8 is on filling of vacancies, and section 9 is on finality of orders constituting boards etc. Then we have amendment chapter, that is chapter 2A, which discusses about notice of change. Here there are 3 amendment sections starting from 9A to 9C, that is notice of change and power of government to exempt, and then setting up of grievance settlement authorities and reference of certain individual disputes to such authorities. Chapter 3 is on reference of disputes to boards, courts or tribunals. There we have section 10, which is on reference of disputes to boards, courts or tribunals, and then we got one amendment section which is 10A to discuss on voluntary reference of disputes to arbitration. Chapter 4 is about procedure, powers and duties of authorities. Here we have section 11 to 21 starting from procedure and powers of conciliation officers, boards, courts and tribunals, and amendment section 11A is about powers of labor courts, tribunals and national tribunals to give appropriate relief in case of discharge of dismissal of workmen. Then section 12 on duties of conciliation officers. Then we have duties of the board. After that it is duties of courts, and then duties of labor courts, tribunal and national tribunal. Then we have forms of report of or award, and then we have publication of reports and awards. Then we have amendment section, that is 17A and B, on commencement of the award and payment of the full wages to workmen pending proceeding in higher courts. Then we have section 18 on persons on whom settlement and awards are binding. After that, period of operation of settlements and awards. Then we have commencement and conclusion of proceedings. And lastly, section 21 is on certain matters to be kept confidential. Chapter 5 is about strikes and lockouts, which has 4 sections starting from section 22 to 25. 22 is on prohibition of strikes and lockouts. After that, it is about general prohibition of strikes and lockouts. Then we have illegal strikes and lockouts. And finally, prohibition of financial aid to illegal strike and lockouts. Then we have amendment chapter, that is chapter 5A, which is about layoff and retrenchment. Remember, there are 12 important amendment sections added via this particular amendment, and they are from 25A to 25J, starting with application of section 25C to 25E, then definition of continuous service, a right of workman laid off for compensation, duty of an employer to maintain muster rolls of workmen, workmen not entitled to compensation in certain cases, conditions precedent to retrenchment of workmen, compensation to workmen in case of transfer of undertakings, 60 days notice to be given of intention to close down any undertakings, compensation to workmen in case of closing down of undertakings, procedure for retrenchment, re-employment of retrenched workmen, and effect of law inconsistent with this chapter. Then comes chapter 5B, which is on special provisions relating to layoff, retrenchment and closure in certain establishments. Here also there are 10 amendment sections starting from 25K to 25U. Now it starts from application of chapter 5B, definitions, prohibition of layoff, conditions precedent to retrenchment of workmen, special provision as to restating of undertaking closed down before commencement of the Industrial Dispute Amendment Act 1976, penalty for layoff and retrenchment without previous permission, then penalty for closure. After that, certain provisions of chapter 5A to apply to an industrial establishment to which this chapter applies, and prohibition of unfair labor practices, and finally penalty for committing unfair labor practices. Then comes chapter 6, which is on penalties, discussing about different penalties with 7 sections, 6 original sections and 1 amendment section, that is penalty for illegal strikes and lockouts, penalty for instigation etc., penalty for giving financial aid to illegal strikes and lockouts, penalty for breach of settlement or award, penalty for disclosing confidential information, penalty for closure without notice, that is an amendment section, and finally penalty for other offences. So it basically discusses about all the penalties between section 26 to 31. The last chapter, that is chapter 7, is on miscellaneous, starting from section 32 on offences by companies etc. Then we have conditions of service etc. After that we have 3 amendment sections starting from special provision for adjudication as to whether conditions of service etc. or power to transfer certain proceedings and recovery of money due from an employer. After that we have section 34 on cognizance of offense. Then we have protection of persons. Then we have representation of parties. Then we have amendment section 36A and B on power to remove difficulties and power to exempt. Section 37 is on protection of action taken under the Act. Then we have power to make rules, and 39 is on delegation of powers, and finally section 40 on power to amend schedules. That's a lot of reading for me. I hope you will listen 2 or 3 times so that you can remember the entire structure of ID Act, which helps you to structure any answer related to Industrial Dispute Act. With that, I am concluding this particular presentation. Thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are referring my channel, and thanks again.